That really was calmer, is that because it was noisy too.
Yes, they are.
You know, banging away at the pocket. Thinking, this is okay. How far can he get it? He's little.
Looks like a vegetarian.
But a couple of years could be.
Not a vegetarian.
No?
They don't have vegetarians in Alabama. That just won't fly.
Is that where you're from?
Alabama, yes, sir.
Oh, right. Accent doing everything, yes.
I think I got an accent. Never want to get mad. Uh-oh. Amazing.
Let's throw stuff at her.
Yeah. Really? First time?
Yeah. Those got too much sugar in them.
We're finishing section 14. We have a few cases left to discuss. We're still looking at constructive trust, resulting trust. But we also have another couple of issues here that are involved with a couple of these cases, and that becomes the ability of civil courts to adjudicate religious controversies. And it actually becomes a subject matter jurisdiction question because the problem that's inherent in those types of disputes is, does the First Amendment preclude the ability of civil courts to resolve those disputes? So, there are a number of different ones, and so I guess at least in part the reason I have these in here is not just because I need you to know the difference between constructive trust and resulting trust, and obviously your ability to define those concepts is important. And again, I'll say this, those of you that have not seen my prior exams should look at the Civ Pro, the remedies ones, and get an understanding of what's likely to look like, and especially obviously the remedies. I think a good way to prepare for the next exam is to look at some of the last ones and make sure that you have a mastery of both the concepts that are often involved in remedies, as well as an ability to be able to address the problem that you may see, because I try not to have a time-sensitive exam, but 3 hours, as you know, still comes and goes pretty quickly when you have to draw on information, and if that information isn't readily available at the forefront of your mind, it means you're going to be under a little more of a time constraint, but it'll be a time constraint of your own making. Because the test itself will not be that long. There'll be an essay and there'll be another section of the test with shorter answers that you'll apply to the essay as well after defining the concept fully. But what you really want to make sure you have a mastery of is the what I think are foreign terms that are specific to remedies. And I'm not looking for a lot of BS in the essay either. I'm looking for a knowledge of the law, an ability to then take that law and apply it carefully to a set of facts, make a good analysis that is well expressed in writing in the paper that I can read, and then some type of reasonable conclusion as to what you think should take place. And again, I think one way to get ready for that is to look at the old exams, and I think that's the most important way, I think, to do it. Because you're down to probably just about a little more than 2 weeks at this point between now and the exam, right? So, and you probably have some other exams that might be certainly less significant than remedies, but equally, that's correct, occupying some portion of your time over the period of the next few weeks.
Professor?
Yep.
I have a question. I'm confused. You mentioned First Amendment. I'm not seeing where it fits here.
Well, let me ask you this. Our church a few years back said...
the church case, the religion case, okay. Yeah, I'm all good now.
Okay. Well, I want to ask the question anyway, even if you are all square, guys. Okay. My church a few years back, our church said, listen, we need more money, we need a bigger church, and if people will pledge money, we're going to expand the church. So... they asked a lot of people to pledge like in addition to whatever you're going to give us another $1,000 a year for the next 3 years so we can expand the church and we can all worship together. And so a number of people did that. And so then over the 3 years they took the money, and then what they said is, we don't have enough priests. We have plenty of unused churches in Lawrence and stuff. We're not going to build it, and we're not going to give you your money back. So I'm wondering You going to go to court for me on that? Can you go to court? I mean, can you get my $3,000 back? Because, this Fortin is a 1994 case, but there are cases now. There's one in Braintree. I think there's one out in Newton where the parishioners are saying to the Catholic Church, and there are others that do it as well, is you can't close this church. This is our church. We worship here. The kids were baptized here. This is our sense of community as well.
Sounds like an ecclesiastical controversy.
And what do you mean by it's an ecclesiastical controversy?
Usually that civil courts are prohibited from hearing these types of matters for lack of subject matter jurisdiction.
So you guys can't get my $3,000 back? That's what.
Not likely.
Not likely.
That's correct.
Well, can you go to court to get my $3,000 back?
Was it a pledge or was it beyond your offering? Was it
Beyond my regular offering? This is what they said. If everyone, if as many people as possible will pony up another $1,000 a year, we're going to expand the church so it's beautiful, it's big, it's large. It's not dissimilar to what a lot of these other folks are saying in other churches. Is you asked us for increased donations and we'll keep the church open. We gave you the increased donations and you said no. And so now my church does happen to be the Catholic Church. Ash says, well, it might be ecclesiastical then, and you might be out of luck. So no 93A?
93 count for fraudulent and deceptive practices only if it's not under the church's authority.
So you can't send them a 93A letter if you think if this is a church matter.
It's not an exchange of goods. It's a donation.
Well, it's a donation in return for promises they made, and now they're not going to honor those promises.
Are those funds being used towards something else for the church?
Yep.
The church?
Yeah. I imagine to pay off some of those sex abuse suits, No, right? I think that had to take a lot of money.
Then it would be hard to get it back because it still went towards the church.
That goes towards the church to pay off the pedophiles.
Well, I don't think they'll tell you that.
But listen, the average award of $200,000, and there were 600 claims in Boston alone. You can do the math. That's a lot of money, right? By the way, is that an ecclesiastical matter? The sex of it's criminal, but so what was the church's negligence in those cases? The assignment and supervision of priests?
Correct.
Yeah.
Well, that's a church matter, isn't it?
Respondeat superior.
Well, they're responsible for the acts. Well, is that respondeat superior? You guys did the Wang test. What was the Wang test? And my recollection is when we had that discussion when it was sexual harassment, the like, you said, no, that's time and space maybe, but that can't possibly be motivated in part by serving the master's interest. Go ahead.
What I got out of it was, if the controversy revolves around the essential church policy and the review of the policy, then the civil courts can't intervene.
And I don't disagree with you at all. I think that's correct to say. I'm not disagreeing, but is that right? So you guys, you can send a 93A letter, but they can ignore it, and they can say, well, if you're going to go, if Ash is correct, where do you go?
You go to the tribunals within the church.
If you've got a claim and it is a church matter, you get to go to the church and seek redress there. Because what's the likelihood there I'm going to get much satisfaction, do you think? You won't.
Well, as far-fetched as it sounds,
fair enough. Go ahead.
The church, they don't answer to no one. That's but to God, and that's their rationale. That they don't have to go to the state and seek.
So my Supreme Court there is the Pope. Oh, is that right? So at the end of the day, if they say no, I'm done. Really?
Well, cardinals anyway.
Well, the cardinal, but at the end of the day, it's the Church of Roman, because Ash says it's not even the Pope, it's the guy above the Pope. And I guess I'll just have to await his word. No. So, but is those are church disputes? Are you just doing this because, at least in part, this is, what if it was the Church of Mike? Because the way I read this, as long as the church has, and I always struggle with this, a hierarchical structure.
Which they all do.
Which, well, not all, You know, that some of them are sort of a flat structure so that you won't have that and they won't have that immunity. But if I structure the Church of Mike with sort of worker bees and then general bees and then sort of the Pentagon, and I create that dispute process within it, I mean, I could take you for $3,000 and say, I'm sorry, you can't go to Superior Court. The Church of Mike has a hierarchical structure, and you must take your dispute to our courts. Is that right?
If you can prove it's part of your religious doctrine or policy, then you win.
Well, and that's the same thing with the $3,000 donation when I was to the Catholic Church. Correct? So, does this also mean then that nuns, Sandy, Rachel, T.D., you have no claims of sex discrimination if you were a nun? Because you can't say Mass, right? And that's a church matter. You're out. It's correct, right? Geez, they treat us like second-class citizens. We get paid less than the priest. The stipend is less than the priest. They don't let us do many things other than we can iron the vestments and stuff. No, really, right? I mean, and you say, well, this is just wrong. In 2013, you can't treat me like this. That's a church matter too? Right? Is that right? And does it make a difference now? I mean, that's the Catholic Church. So the Church of Mike requires you to donate your services on a regular basis to the church.
What about the fact that, I mean, you're telling me that a nun's getting raped outside the church?
I said the nun's getting raped?
Is that what you said?
No. Play the tape back on that one, Sandy. Hold on. No, I said they're being treated as second-class citizens. And which they are, aren't they? I mean, isn't this partly what I think some people hope, that maybe we'll have women priests and women be able to say Mass, but you can't now, right? Women in the church. And it's not just, I'm just picking a church that I'm familiar with, but Orthodox Jews, you can't even sit in the same location in the temple. And again, there's other religions as well, but that's a church matter. Is that right? In the Orthodox religion, you can't get a divorce unless the husband agrees to give it to you. It's a get. You got to get a get. And if he chooses not to give it to you, you can't get it.
Sounds right to me.
That's right.
No, that's the rule.
That's right.
That's the rule. And that's the rule. And so part of this is, I guess, I think you may not have even known about ecclesiastical courts before now, but I think you have to figure out you have to have a little bit of knowledge about this, because people don't, when they come in sometimes, they will say, especially if you could do family law work, for instance, they'll say, I would like a church annulment as well. So how does that process work? Right? I would like the church to annul my marriage. Now there's a civil annulment and a church annulment. And even the get. So there's another series of courts that actually is nowhere near as transparent as our present ones. So I'm wondering what really makes something the church matter versus what makes something the civil matter. Because the last case in this sequence that I gave you here from Westlaw is it's Sandy's case, and I called it Sandy's case because at one point she was sitting in this class. The Episcopal Diocese of Mass versus Divine. That case, the last case in the sequence, is Sandy's, and she took this class, and she was sitting here, and what she felt is, well, the Episcopalian Church treats me in a second-class manner. I mean, I mean, you guys can jump in any time you want, but right? Many churches many religions, there is a significant distinction between the role of men and women.
Yeah.
Yes.
But that's okay. Or it's not okay, but it's a church matter. You can't do anything about it, and the civil courts won't touch it at all.
You answered it.
Yep, you're right.
So, what about my $3,000?
It's gone.
It's gone. Because it's a church matter. And it doesn't make a difference which church it is. Because there's some of these funky ones that we don't quite, right? No, like the Church of Mike. So the Church of Mike can say, okay, all of our worshipers, if you want to be a priest or priestess, you have to tithe to Mike 50% of your earnings, and you can't have sex with anyone other than Ash. I'm not going to make it Mike. Lucky for Ash, who's sitting next to me. No. And that's a church matter?
Well, religion's voluntary. I mean, you don't have to be part of the Church of Mike. Ash might write policies of the Church of Mike.
No, but that is right? You don't have to be, so you choose to be. Doesn't sound like some of this is potentially subject to some scams and stuff? You all will tithe all your money to me, and I will tell you what you can and can't do.
But you have to be established as a church under the IRS rules, right?
But how difficult would that be? We're lawyers.
It's not difficult.
Just get a tax ID.
Okay, right? I mean, look at all these little churches that, when things come to light, we say, boy, that's kind of funky. So I mean, it can be done, but so...
I'm thinking, what happens if you go to Foxwoods and you get hurt, and
Well, by the way, right? Exactly. Go ahead.
The tribe is its own sovereign nation, and they have their own internal court system. So Connecticut has no jurisdiction.
Well, right. Again, talking about subject matter jurisdiction, stuff happens on sovereign land of the casinos down there.
But
you're out.
Isn't there some, say, on a rate? I don't know, but public safety or national security, there's exceptions.
Well, maybe for national security, but slip and fall in the casino or a lot of that stuff.
So where's the
you're even DUI on the casino land.
What about murder?
Well, my guess, some of that will be touched on with respect to the federal statutes that would regulate the casino operation. But and I think I just saw it, there is I think the Supreme Court just took it, just heard the case. And this came to light, I had no idea it was even in operation until I had a case early on as a lawyer. And this is the case the Supreme Court just took. If a child who is part Native American is going to be adopted, there is a process that requires, almost mandates, that child prior to being adopted by white parents, the statute and the preference is that the child, absent good cause, and more than good cause is the way it reads, the child has to go to a Native American, and preferably the parent. That's what it says, because of it's a Native American Protection Act or something like this, and that's the case the Supreme Court either resolved or heard. The child had been with adoptive parents for 3 years. I think adopted. I think it's even worse. And then what they said is the act wasn't complied with. The father, who didn't want the child at the time, wasn't prepared to support the child, now has to receive the child back because it's part of this act. So, I mean, there are things that take it out of operation of states' laws, as Ash points out, with respect to your typical falls and maybe your less significant criminal matters that take place on Indian land. And some of these cases, as you start to look at it and say, whoa, wait a minute. So even things such as donations. I was involved in the sexual abuse cases, and the church did, I think surprisingly, but maybe not, it was surprising to me, but the argument had greater legs than you'd think. That one of their major defenses was that it was protected under the First Amendment, and therefore the civil courts couldn't touch these damage claims, because if anything they should be resolved in ecclesiastical courts. And at first blush it sounds crazy. If you take a step back, as best I will present it to you on their behalf, because I didn't buy it and still don't, but the argument is the negligence comes from the supervision and assignment of priests, right? In essence, you're saying because the liability comes not from respondeat superior, but because they negligently did something, right? Because he's not in the course of employment that activity. What makes the church negligent and responsible is when they don't properly supervise the behavior and it takes place under their direction, their negligence. And so what they're arguing about and what some of the liability was predicated on is we knew X was doing these criminal acts and abusing children. Nonetheless, we reassigned them to another parish. And then, they perpetrated similar types of acts. And so what the church was saying as part of its defense is the assignment of priests and the education of priests, that is completely within the church's domain as an ecclesiastical matter, which it is, right? Who we assign to a parish and what educational tools we give them, that's our job. And you really frankly can't say that doesn't involve a church matter. And so therefore, if that's where our negligence comes from, and I think it does, then this is an ecclesiastical matter. And it's not an argument necessarily without some merit to it. But I adopted the approach that Patrick adopted as well, and it doesn't need to be a long brief, but the argument is, and really the brief was relatively short, the First Amendment was never designed to protect criminal acts. And that's what we're talking about, is adults having sex with children. But you'd be surprised how often one can invoke the ecclesiastical courts. So the case talks to me about a distinction between congregational and hierarchical churches. So what's a congregational church?
Protestant.
Well, what's it mean though? Because we're trying to look at the distinction. Because what they really want, the owners here, well, not the owners, the plaintiffs, want a resulting or constructive trust placed on the church. Because, unlike the situation I described to you, they said, listen, if you guys raise enough money, we'll keep the church open. We just worry about it being a drain. And in fact, they went ahead and they raised the money, right? And then the church said, you know what, I'm sorry, we can't keep it open anyway. And frankly, this problem has gotten significantly worse since '94 because we have more older churches in need of repair and fewer priests to man those churches. So it's become even a more significant issue with respect to these parishes being closed. And so the question becomes, can they get the trust over the property? Here it says the parishioners funded the construction of the building, which cost over $1 million in the 90s. And this structure serves as the parishioners' house of worship until the bishop's direction to close it. They then raised another $600,000. The bishop nonetheless said, no, we're closing. So how do they try and address these issues? Because it would seem to me, and this is probably, not just probably, these types of things touch people emotionally, so it's obviously not just about the money that's been pledged or lost, but they feel like they're losing part of themselves, right, their life. Civil court? Ecclesiastical court?
But I think the church is probably, in any of these cases, whether it's criminal or civil, is going to raise the prospect of the possibility of ecclesiastical in order to increase their bargaining position no matter what, I would imagine.
Well, there's no doubt about it. But isn't the opening or closing of churches, doesn't it sound like a matter involving church policy? This is not just thrown out there to see if it sticks.
Definitely.
They got a legitimate argument that we should be able to do what we want obviously you couldn't say, teach this as part of the prayer or teach that. Where we worship and how we spend our money has to be a pretty significant part of running the church as well. Tell me about this neutral principles of law, because it does seem to also talk about, well, maybe you can bring it to civil court and have a court process of adjudication if it can be resolved using neutral principles of law. What is that about?
Outside of the hierarchy, outside of the religious doctrine, polity, and I think they reference something else. Basically, it's a separate matter that doesn't have to involve church policy or church religious decisions.
Well,
separate point of law altogether.
Okay, so there's a separate and distinct point of law upon which it can be resolved that doesn't involve church matters.
Do they mean?
Go ahead.
Do they mean bylaws of like organizations?
No, I don't think that's what they mean there. I'm looking at the language. It's just in my book. It's at 786. It says, probably the most notable departure from the traditional notion that civil courts ought not to resolve church property disputes came with Jones versus Wolf, a 79 case, in which the Supreme Court said states, and it's now being resolved by a state, are constitutionally entitled to adopt, quote, neutral principles of law to resolve church property disputes. Thus, if a dispute can be resolved without inquiry into matters of religious doctrine or polity, a court may examine such sources as A, statutory provisions governing the holding of property by religious corporations, and B, the Constitution, this is the second part is what you would say, the Constitution and bylaws of the religious organization involved, especially insofar as they pertain to the ownership and control of church property, and then C, the deeds of the property in question to resolve the dispute. And then it goes on to say, as an alternative, this court has in the past focused primarily on the distinction between the organizational structure of the church to determine when jurisdictional is appropriate. If the organizational structure is flat, such that there really isn't this appellate review and any type of internal governing of disputes process, then you don't get to fall in line behind the First Amendment. But if you set up your own internal system of dispute resolution, as archaic and inaccessible as it may be, because I mean, historically, the process of an annulment, for instance, in the Catholic Church, is shrouded in secrecy. Joe Kennedy's wife wrote a book about it and said to me, "What's the chance of her successfully opposing the Kennedys in the Catholic Church in Boston?" Because the process is just shrouded in secrecy as well. But it does talk about if, in order to fall within it, it must maintain an internal system of tribunals for resolution of disputes. So we've got two. Go ahead, Ash.
I was just kind of saying, under the neutral principles of law analysis, when I read that, that kind of tells me like where would the claim be if they left the religious aspect, separately.
Well, and let's look at it from that standpoint, because that is where I think they ultimately start to look at this. You want a constructive trust. You want a resulting trust. Let's see if either of those principles are going to be able to resolve this as we look for it. It says, first, there's no basis for the plaintiff's claim that a resulting trust arose from the 27 conveyances. And then it says, a resulting trust in real estate arises where one party furnishes the consideration to purchase the property, not intending a gift or advancement, yet title to the property is taken in the name of another. And then it goes on to say, a resulting trust must arise, if at all, at the time of the execution of the deed. So Ash provides me the money, says I can't take title in my name, put it in your name for now, Mike. In essence, what we sometimes will call a straw. Their name goes on the deed. If the trust arises at all, it arises at the operation of the deed, and he's furnished the consideration. He doesn't intend a gift or advancement. He intends me to hold it on his behalf, and the name goes for me in my name just for paper purposes. Problem with this is There's the only two people who know that it's paper purposes, and the only evidence that exists about that is our testimony. This is why problems come in. And this stuff comes in all the time, not in the context of church cases. Sandy wants to take care of me in my old age. And I say, okay, Sandy, how about I'll put your name on the bank account so that you can pay my bills and stuff if I get sick. And so it's a $100,000 bank account. I get a little sick. Still, by the time of my death, there's $90,000 in the bank account. The remaining joint owner is Sandy. That's what it says. It was for Sandy and Mike Coyne. Sandy, remember that 90 is supposed to go back somewhere else? Most people don't, right?
It sounds like Nasrallah.
Well, and that's right. And this becomes the problem. And this happens a lot. A lot of people think they can avoid probate simply by putting someone else's name on it, and they'll do the right thing later on. And oftentimes the right thing isn't done, but trying to prove it becomes problematic. Bank accounts is quite frequent between, sort of the older parent and a younger child, simply to access for payment of bills and food and that type of thing. But it oftentimes creates this type of problem. And one of the things we look at to try and resolve that sometimes is the notion of a resulting trust. Is the name was put on it. There's no evidence of a gift. And at this point now, that property should belong to the estate of the decedent, not the other person whose name is on it. But if you look at it, what it says is that the resulting trust, one party furnishes the consideration, not intending a gift or advancement, yet title is taken in the name of the other, and if it's going to happen at all, it arises at the time of the execution of the deed. So that's what's central there, is that in essence that the straw's name has gone on it. Goes on to say a resulting trust is where one party furnishes the consideration and another party takes title. If we look at the bottom of that page in 789, it gives us another definition of constructive trust. And this is obviously Nesarella. Under Mass law, a court will declare a party a constructive trustee for the benefit of another, and we said this is done to avoid unjust enrichment. They both really are. If he acquired the property through fraud, mistake, breach of duty, or in other circumstances indicating that he would be unjustly enriched. I mean, fraud, mistake, breach of duty, or in other circumstances indicating that he would be unjustly enriched. Well, which is it that even comes close to satisfying this standard? Okay, you gave us some. I'm sorry, go ahead.
I was going to say probably the third.
What do you got for the third?
The third part of the test?
Oh, the third part of the test. Or, well, you're sort of using the generalized language, or in other circumstances indicating unjust enrichment.
Yeah.
That's about the best you get, right? I don't think there's fraud. Well, in my case with that $3,000, you'd have to say the fraud was that they never intended to do it, not a change in circumstances. It's not really true. In my case, by the way, they did build the church, but there's a lot of other situations, I think, where a lot of people, the case itself, they pledged a lot of money, they put a lot of money in, and nonetheless, changed circumstances had the church doing something different than what the people were told would be likely. Not really likely, we told would be done. I guess I'm not convinced that you all are so willing to give the same type of protection, although the law seems clear, to the Church of Mike. Or, right, the Wiccans. Whatever. Less mainstream religions. Maybe disfavored religions now. Would you give them the same protection?
I don't see how you could make the exception. I mean, if they're qualified under the law, they've got the hierarchical structure, and everything else is in accordance with legal requirements. I think you'd have to afford, at least for lack of a better, a lesser church the same.
No, that's fair. I mean, the law is the law, and I really did want to make sure that you recognize it. That the fact of the matter is, if someone and listen, and by the way, there's a lot of small and storefront churches scattered throughout Lawrence, And so, I mean, the law is clear. I think the law is clear on it. And if you were to advise a church, if someone came to you, said, I'm thinking of starting a church.
Good idea. Make it hierarchical.
Well, no, exactly, right? I mean, because this is something you should be aware of, is that, well, there are ways to protect the operation of that church that makes it more difficult to get to establish liability and to grab assets. That is your job, right? There's nothing wrong with that. In fact, I would expect that you should advise along those lines. And you're going to probably do the 501c3 for the nonprofit. You're going to file your corporate papers. I mean, there's a fair amount of work that's coming out of this. But there's also a fair amount of protections that you can apply. And I think over time it becomes amazing as you start to see how this can affect it. It's not going to affect it here, and there's been a number of other pieces within Mass in the last few years because the church is rapidly changing and making significant changes with its operation and the like, and there'll be more coming. And then it goes. So it can't be a resulting trust. If it's a constructive trust, the best it gets is to sort of use this general language at the end. If they apply those principles, these folks are out. You can't get your constructive trust. You can't get a resulting trust. And beyond that, it sounds like it's a
Tax deduction.
church matter, and that's the other part, right? Even the first part, not intending a gift or advancement, and obviously, you guys already pointed out that's one of the arguments here: is you donate to a church, you donate. Sometimes people restrict their gifts. I'm providing this, and we've seen this. I'm providing $10 million so that you will build the wing of the hospital and name it after my mother.
Well, that's not a gift.
Well, it's conditional, right? And so we are looking at different situations under those circumstances. If they're restricted, you may have more control over it. It says here, we note in closing that undoubtedly due to inadvertence, the judge did not enter a declaratory judgment regarding the status of the property. Declaratory judgment we looked at before is a declaration determining the rights and obligations of the parties to a real or threatened controversy. And that's what the court should have done here because that's what the plaintiff was seeking. And so the court sent it back there to determine that. The next case is Nessarella versus Peck. And again, we're trying to argue about resulting trust, constructive trust, and I think they do a nice, they give you a nice analysis too here as to what you'd be looking at here. So what happened here was he talked to him about a good deal because we've got an action seeking specific performance of an oral agreement to convey a tract of land. And specific performance is an equitable remedy where you're asking the court to order the defendant to comply in accordance with the terms of the contract. And it was a farm, and he tried to get a. Why did he want this other guy to be involved in trying to purchase that property?
The owner didn't like him.
Yeah.
Right. Or he didn't like him.
Right.
Said he wouldn't deal with them, or he felt he wouldn't deal with them. And it's not uncommon either. It's also not uncommon that people will contact you and either want to remain anonymous or will use a false name because, I mean, listen, if you knew Bill Gates wanted your seaside home, the price goes up, right? No, really, right? What was it? What's that girl's name? Girl bought the house in Hyannisport and then sold it. Taylor, Swift, right? That you want to buy through a trust or something, so that you don't know. Because if I know you want it and you want to be next to your boyfriend, the price goes up, right? So there are legitimate reasons for doing it, here, what he tried to do is provide him the information in hopes that he would do what he said, and so what happens here is
So he took advantage of the information obtained.
He took advantage of that information and decided he was better off keeping the deal for himself. Slime. Which, by the way, I mean, I shouldn't have to point out to you as lawyers. I mean, you'll have opportunities to receive confidential information as well that perhaps you could personally profit by. Obviously, that would likely result in your disbarment sooner rather than later. But it is, you know, you do have to be careful. So, and sometimes it's not like this, like where it would be to the detriment of your client, but you receive information about, you know, potentially companies going public and things like that, or, you know, misfeasance instead of corporation that maybe you own stock in and stuff. And so there are other parts of this as well. But here, this is just sort of flat out, he takes the deal for his own because it's a pretty good deal. It says here, the former judge, because the judge went to the federal court, who was it, Young?
Yep.
Okay.
He had problems with the finding of facts and conclusions.
Which doesn't make sense. Young is, you know, I've got Young, there's a series of evidence tapes by Young and the like. It just, I guess sometimes stuff happens. He enters a judgment dismissing Nesrella's action, but as we know under Rule 52, we learned early on in this course, he's supposed to make findings of fact and conclusions of law to support the judgment. We also know from one of the other cases we read in that sequence is those can be oral as long as they're delivered into the record and then they're recorded by either the tape recording or stenographic. But there were no findings of fact at all here. He simply said one party wins, the other loses, and that's precisely what Rule 52 is designed to protect against, sort of these decisions that one can't look at to determine what the support for it is. What he felt is that the plaintiff hadn't established a claim. It says a second Superior Court judge entered the findings of fact and conclusions of law to be entered nunc pro tunc to May 23rd, 1985. What's that mean?
Correcting
Now for then.
Now for then. Do you know Latin?
No.
You looked it up?
I looked it up.
Oh, okay, good, Ash. But that is what it means. Nunc pro tunc means now for then. And I've had to do that more than a few occasions. If there's a mistake, then you need to retroactively, in essence, fix it. And so it's a phrase and an expression that you should be familiar with in practice to correct the gaps, to enter the order as it would have been, and to make it effective as of that date. Nunc pro tunc, now for then. And so the court went in and revised them, issued them, in essence, as they should have done from the outset. And then it talks about Rule 52, and I think it is important to, again, go back and think about what Rule 52 is designed to do. Remember, there's no jury here, and so what you're asking the judge is to set the reasoning down for their decision. And again, it becomes important simply so that the parties can see how it's arrived at, and the parties don't simply feel, well, he didn't like me. There's a basis for the decision. You may not like the basis, not feel it's supported, but again, one can look at the logic, look what the findings are, look to see if the support is in the record for that, and if it's not, then again, you have a different basis to challenge. But if it is there, and there's a basis to be able to see it, people who lose, even if it's fully explained, are not going to like, still going to feel it's personal, many of them. But this is supposed to ensure that there's an adequate record then to review on appeal. There's a million excuses as to why it's not done, but in that situation, at least in the state court, probably isn't much better. Federal court's a little better these days. A federal court actually has significant support, administrative support to help them. State court is still a little tough. So tell me, why can't it be a constructive trust?
Fraud.
No fraud, yes.
No fraud. So even stealing your deal doesn't make it fraud.
Well, it has to be clear and convincing. They don't look at...
Right, fraud is by clear and convincing. And why can't it be resulting trust?
Consideration.
He didn't furnish the consideration. Right? Doesn't sound right to you, though, does it? But it's not really going to fit what we might like it to fit here. He didn't furnish the consideration, so we can't get the resulting trust. Why do you say constructive trust? I'm thinking of Sanguinetti, and it sounds like it should fit some of Sanguinetti, no?
It's just sleazy. It's not like, it wasn't like it doesn't mean all the elements of fraud, I guess. Which I don't know the elements, so don't ask me.
Well, okay, listen. I'm looking at the language on 762. It says, a court in equity generally may impose a constructive trust, quote, in order to avoid the unjust enrichment of one party at the expense of another, where legal title to the property is obtained by fraud or in violation of a fiduciary relationship. They don't, and then the court goes on to say, there is no fiduciary relationship. Sanguinetti was his lawyer, so it is different. But is that right?
Mm-hmm.
We're friends. I talk to you. I see if you'll do this for me. You say, yeah.
That doesn't constitute fiduciary relationship, though.
Right.
Not unless, I guess, we were dating from my last conversation in Sullivan versus Rooney. And I don't know about dating, by the way, whether I would agree that obviously that relationship was more than simply dating. But I do worry that you guys set a pretty low threshold for fiduciary and trusting relationships there. I'm not sure the court would agree with you in all of that.
I think if he has anything, it's where information confidentially given or acquired is used to the advantage of the recipient at the expense to the one who exposed the information.
And so why doesn't that get us anything? Because that sounds like precisely what happened, right? Information confidentially given is used to benefit one at the expense of another.
But there was no real expense.
Oh, so now we're going to enforce the statute of frauds. Forget Sullivan versus Rooney, where we decided to abandon the whole notion of statute of frauds to avoid unjust enrichment.
There's some level of unjust enrichment, but the court just can't get past the argument of the statute of frauds.
I thought I should have gone after him as a realtor, not as a son-in-law, though. I mean, if you work with a realtor company saying, hey, when this comes on the market, and they say, sure, and then it comes on the market, well, you know, wouldn't you go after a cold old banker as opposed to your son-in-law, who you're probably going to make your daughter's life hell?
But Cole would probably be in a fiduciary relationship. If you got in a relationship with a professional real estate agent, that would be fiduciary.
Well, he is a professional real estate agent.
Right.
This guy was?
He's part of Cumberland Farms, the dairy, the retail branch, and VSH Realty.
Mm-hmm.
Okay, so
I was talking to
So if you had a realty
Techno
agreement.
VSH Realty, and I asked him about a real estate transaction, and he went through with the real estate transaction we discussed, and then conveyed it to him and two of his co-workers as part of VSH Realty. And I was like, why didn't they go after that angle? They probably lost, but...
Well, they did go after VSH Realty at the end. In essence, they throw it out with a sort of, again, just a brush of their hand at the end, saying the claims against Peck are groundless. It follows that the claims against VHS Realty and Lily Bentis are similarly without merit. I mean, it does seem like information confidentially given is used to benefit one at the expense of the other. But I think you're right. I think they can't get around the statute of frauds problem, which, I mean, I feel more sympathetic. Well, I feel equally sympathetic to both plaintiffs here as in Sullivan versus Rooney. But I wonder how we can so easily discard the statute of frauds in Sullivan versus Rooney and then use it, I think, correctly. So, in this case, the last case that I asked you to look at was the Divine case. And is that right, though, that your nun comes in to see you and says, "Oh, look, I got to do all this menial work, and I can't do X, Y, Z." You don't have any sexual harassment claims? You don't have any sexual discrimination claims if it's, in essence, against the church?
No.
It's what you signed up for. You signed up for no sex and in a pretty subservient position. The law can't touch any of that. Because you know what I worry a little bit about? You know these churches that we see like in the Midwest and Southwest, we'll say, where, you know, like the older men are taking advantage of the young girls.
Polygamist?
Yeah.
Polygamy.
more.
Well, say it's not polygamy, because polygamy just means we're married, right? So, okay, I won't marry. But I have sex with all the young girls. That potentially is protected church activity?
No.
Why
Didn't work
not?
out so good for the Branch Davidians down in Waco.
No, but there are a number of churches like this, right? That we live as in a commune, in a community, and we have certain rules there. And unless the what?
That's not church.
That was the 60s.
No. You're saying it's a what?
It's a cult.
It's,
That's not
okay, but see this. Okay, now see this is okay. But here's where my problem comes in, Sandy, and this is the problem I had that you all disabused me of. It's a cult because we don't like the church's activities. It's a disfavored church, but as they would see it, it's a church. We have one such one in Plymouth. They did a whole story in the paper on them. It was very interesting. I didn't even know there was one like it in Plymouth, Mass. But it doesn't sound like much different when everyone pledges all their earnings and they pray and they do a whole bunch of things together that I and some of you would see more as cultish. But these are protected activities unless they're children, so that we're talking about rape and statutory rape and things like that. But religion has such power. It would seem like you might want your civil courts to reach some of this, but no, because you only call it. I mean, look at my church, right? There's some cult-like behavior with it, and people, right? You can't have sex. Men and women who belong as priests and nuns can't have sex forever. That's a little cultish, isn't it? No, it isn't. You abstain.
I don't think abstaining is cultish, but I think when you dictate to the nun,
I'm dictating sexual activity.
Your doctrine to the nun is you have to have sex with the higher priests because that's the. I mean,
it's voluntary.
Yeah, if you want,
either's voluntary.
So be it, but.
No, right? You're saying it's voluntary. What's voluntary? You're saying it's voluntary not to have sex, but it's involuntary to have it. I mean, it seemed like...
Well, look what happens sometimes when they disagree with the church. Like when they were trying to elect a new pope, they were trying to lobby for rights to that, and they're like, well, now we're going to disavow you, you're gone. Good luck with that.
Which is a church matter. So you don't have First Amendment rights either?
No.
Not within a church, no.
Okay. Within my cult? I mean, because I'm calling... I'm calling you out on it. You're the one that said, oh, no, that's not a church, it's a cult. But it's not. Structured appropriately, these are our beliefs. Right? And that is outside a civil court's review.
Yes, sir.
That's the teachings of the cases. That's isn't it? Or I'm just.
But does it matter if it's set up like when you said the person comes to you wants to start a church, you get to set up the corporate filings, the 501c, all that. What if a cult? Let's call it a cult. Doesn't have all those filings. Does that deny them the protections that the law offers?
Well, I don't know what filings. The 501c3?
The nonprofits and the...
I don't think I have to have a 501c3 filing. What I have to have is the appropriate structure. The 501c3 filing just makes it easier not to have to pay taxes and do all, not even pay taxes on my real estate potentially. So the benefits to that are separate. Then it's more important to have that structure.
So you just need an internal structure for resolution.
I need an internal structure for dispute resolution. That's what their case says. The 501c3, the rest of it's great. It means I get to keep more of my money.
So you have Mike, you have Ash, and then you have the rest of the congregation.
Yeah, right.
There's your hierarchy.
Ash will be the supreme being. Sounds more right. He'll be. The supreme. I don't mean to be offensive to someone. Ash will be the supreme ruler. He'll get the last word on everything.
But I answer to God.
And that's right. That's because he speaks directly to him. So it's more appropriate that Ash get the last word. And and that would work. But it is cultish, isn't it, Sandy?
Yes.
Okay, so tell me, that's all. I mean, this is what I'm worrying about when I look at it is some of the behavior when we see it in other organizations. We say, oh wow, but it would seem to me regulating adult sexual activity among the consenting people seems cultish. restrictive.
Fine consenting.
Well,
I mean, just because they say yes doesn't mean it's
people
consensual.
who have free will and have the mental capacity to consent, if they agree to do it,
Choice.
huh?
It's their choice.
No,
It's anyone's choice then. So
Correct.
why do you pejoratively call it cult when it's
Because they play on weakness and insecurity. It's like, well,
so
any
there's no
religion
insecure or weak priests and nuns because that's our church. That's okay. What did you say?
Church-
What about the Wiccans?
The Church of
What about
Scientology has been accused
You a
of
Wiccan, Sands?
What about them?
That's not cultish?
No.
What about,
Sandy's the high priestess.
isn't there like animal sacrifice and stuff and some of that? Isn't it? Listen, what is, and again, I'm not trying to, doesn't Santeria have animal sacrifice and the like?
True.
Right? Huh? I had a client who was the priestess. No? I mean,
True.
so,
That's
I mean, is that,
case.
I'm sorry?
There was a Supreme Court case for animal sacrifice. The chickens were cutting their
Right.
head off and
Well, smoking hemp, right?
health concerns.
Important to my religion, the ganja right there. And by some of those, the court said, not so much. Not so much essential part of your religion.
The Church of Scientology is being accused of kidnapping people that try to get out of the church and all kinds of stuff.
The dean litigated for years down in Clearwater with the Church of Scientology, where they're headquartered. All sorts of issues related to money and taxes and everything else. You don't have to like the church for them to fall within the protections. And I do, I'm good with it at this point. But I do think what we got to recognize is that First Amendment is going to protect a lot more activity, potentially. And this whole notion of ecclesiastical courts is actually much broader than you might think. I also think it's important just to understand, I've had clients question, I had one question me one time, you're a Catholic, are you going to be able to represent me in my divorce? Listen, what I do outside of my law practice is different than what I would do inside. And in fact, I had a number of cases against the church with respect to the sexual abuse thing. I think your views of the world are important to how you practice, but I think you've got to recognize that you will have clients, there's a separation, that will have diverse religious interests. And actually, I was sort of looking forward to the whole notion of, because you want both the get and the civil divorce. For 10 years, she wanted it and didn't do anything. She'd come in and talk probably once a month. I think I'm going to do it now. I think I'm going to do it. Let's do it. It wasn't 10. It's probably 5 full years, honest to God. And
Did you have to go to confession?
for many other things, but not for that. Good.
You couldn't compel the get for her. I mean, you could do this. Okay.
No, there's actually, if you research and look at it, there's nothing you can do.
Okay.
Nothing.
But you went there civilly and done it for her. But
You can get a civil divorce, and civil divorce is going to be, it's going to be operated by the state, obviously. But you couldn't even go in to get an this, in my opinion, you couldn't go in as part of your civil divorce and get an order ordering him to give her the get. Because that would involve a church matter. It's not possible. I don't see how the court could legitimately order that as part of your civil divorce, because it is entirely within the religious views and the requirements of the organization.
I thought she was talking to you about the get. In addition.
No, she wanted me to help her get a divorce and to get him to give her the get. So, anything else? We're done. One more week. So, whatever questions you have, let's get them together. Let's figure out where we're at next class.